On the morning of November 18, 2022, in a probate court in Holmes County, Ohio, a 64-year-old widow named Verena Schoenfeld stood before Judge Adelmar Reinhold and listened to the attorney for Heartland Federal Savings Bank explain why her late husband's farm, 320 acres in the rolling hill country of East Central Ohio, would be transferred to bank's possession within 90 days. Her husband, Matthias Schoenfeld, had died of a heart attack on August 4, 2022. He had been 66. He had left behind a $512,000 agricultural loan, originated in 2019, secured by the family farm. Verena had not been a co-signer. Her name was on the deed only as a marital interest, which under Ohio probate law meant nothing against a properly secured agricultural lien. The bank's attorney, Henrietta Callaway, presented her case in 19 minutes. She submitted the loan documents. She submitted the death certificate. She submitted the default notice that had been mailed to Matthias on the day before his funeral, which Verena had never opened. She requested the court approve the transfer of the property to the bank's loss mitigation department. Judge Reinhold reviewed the documents. He looked at Verena, who was sitting alone at the defendant's table in a black wool coat that had belonged to her mother and was 3 sizes too large for her shoulders. He said, "Mrs. Schoenfeld, do you have any response to the bank's petition?" Verena stood up. She had not slept in 19 days. She had spent the previous 3 weeks emptying her husband's office, soaring through 53 years of accumulated farm records. She had not expected to find what she had found. She held a manila folder in her left hand. Inside the folder was a single document, yellowed, folded into thirds, dated August 7, 1968. The document had been buried in the bottom drawer of her father-in-law's old farm desk, beneath 54 years of receipts, tax returns, and seed corn invoices. She had found it on November 14th, for days before the hearing. She had taken it to a paralegal in Millersburg, who had taken it to an attorney in Worcester, who had taken it to the county recorder's office. By the morning of November 18th, 3 different attorneys, 2 paralegals, and 1 assistant secretary of state had reviewed the 1968 deed. All 5 had reached the same conclusion. Verena did not yet fully understand the conclusion herself. She had been told only that the document changed everything, and that she should hand it to the judge before any other testimony was given. She said, "Your Honor, I would like to enter this document into the record." She walked to the bench. She handed the folder to the bailiff. The bailiff handed it to Judge Reinhold. The judge opened the folder. He removed the document. He unfolded it carefully. He read the first 3 lines. Then he stopped reading. He looked up at Henrietta Callaway. Then he looked at Verena. Then he looked back at the document. He read the entire deed in silence. It took him 4 minutes. When he finished, he set the document down. He removed his reading glasses. He folded them carefully and placed them beside the deed. He said, "Mrs. Schoenfeld, please be seated." Verena sat down. Judge Reinhold looked at the bank's attorney. He said, "Counselor, we will be taking a 15-minute recess. I would advise you to use the recess to contact your firm's senior partners and request immediate guidance." He banged the gavel. He stood up. He walked into his chambers and closed the door. What had been on the 1968 deed, what had been hidden in a desk drawer for 54 years, what Matthias Schoenfeld himself had never seen, what would in the next 90 minutes overturn foreclosure that the bank had considered uncontestable, was a single legal mechanism that had been written into the original transfer of the farm from Matthias's grandfather Otto to Matthias's father Albrecht in the autumn of 1968. The mechanism was called a Family Preservation Reversion Clause. It had been a common feature of agricultural deeds in Ohio's German-Mennonite farming communities throughout the mid-20th century. By 2022, it was so rare in modern title work that the Assistant Secretary of State who reviewed the document had told the Holmes County Recorder that he had seen only 2 such clauses in 23 years. What the clause did was simple. It made the property unforeclosable, not by a third party, not by any creditor, not by any bank, not under any circumstance, for as long as the property remained in continuous family ownership and was actively farmed by a direct descendant of the original grantor. The bank had foreclosed on a farm that, under the terms of its own deed, could not be foreclosed. This is the story of how Verena Schoenfeld found that deed, what she did with it, and what one Mennonite farmer in 1968 had quietly built into a piece of paper that nobody had remembered to invoke for 54 years. If you're enjoying the story so far, don't forget to hit the like button and subscribe. Drop a comment telling me where in the world you're watching from. I love hearing from you. The Schoenfeld farm sat on 320 acres in the rolling hill country of Holmes County, Ohio, for miles south of the village of Berlin. The land had been in the family since 1903, when Matthias's great-grandfather, Friedrich Schoenfeld, had purchased the original quarter section from a Swiss Mennonite settler named Caspar Yoder. The farm had passed from Friedrich to Otto in 1932, from Otto to Albrecht in 1968, from Albrecht to Matthias in 1991. Matthias had farmed it for 31 years before his death. Matthias and Verena had been married for 41 years. They had 3 children, 2 daughters who had moved to Columbus and Akron, and a son, Roland, who worked as a veterinarian in Holmes County. None of the 3 had wanted to take over the farm. The 2019 loan had been a mistake. Matthias had taken out to expand the operation, to purchase an adjacent 80 acres from a neighbor's estate, to add a 3rd grain bin, and to upgrade the milking parlor in the dairy barn that Matthias and Verena still operated with 38 Holsteins. The expansion had not been necessary. The existing operation had been profitable. But Matthias, at 63, had wanted to leave something larger than what he had inherited, and the banker at Heartland Federal Savings, a man named Bertram Lindquist, had encouraged him. The encouragement had been persistent. Bertram had visited the farm 3 times in the spring of 2019. He had run projections. He had assured Matthias that the loan was structured for an aging operator with no farming heir. Matthias had signed a loan agreement on May 18, 2019. The principal was $448,000. The collateral was the entire 320-acre farm. Verena had not been at the signing. In the German-Mennonite custom of his generation, Matthias did not consult his wife on financial matters. He had told her about the loan 2 days after he signed it. He had told her not to worry. She had trusted him. By August of 2022, when Matthias died, the loan balance had grown to $512,000. The dairy operation had been struggling for 2 years. The expansion had not generated the revenue Bertram had projected. Matthias had been making minimum payments for 16 months when he died. The interest had accumulated faster than the principal had been retired. The bank had filed a default notice on August 3rd, 2022, the day before Matthias's heart attack. Verena had been at the funeral home that morning. She had not opened the mail. She had not opened any mail for 6 weeks. When she had finally begun, in late September, to sort through the accumulated correspondence, she had found a default notice. She had taken it to her son Roland in early October. Roland had read it. He had been silent for a long time. Then he had said, "Mother, we need a lawyer." Roland had paid for the lawyer, Conrad Yutzi, who practiced agricultural law in Worcester. Conrad had reviewed the loan documents and had told Verena, in plain language, that there was very little he could do. The loan was properly secured. The default was real. Matthias had not been a co-signer with anyone, had not maintained a separate insurance policy, and had not, despite Bertram Lindquist's verbal assurances, included any provision that protected the family's equity. Conrad had told her, "Mrs. Schoenfeld, the bank has a strong legal position. I can request a delay. I can negotiate a longer transition period. I cannot stop the foreclosure." Verena had thanked him. She had gone home and started cleaning out her husband's office. She had not been looking for a deed. She had been looking for closure. What she had found instead was a piece of paper that her father-in-law Albrecht had filed in the bottom drawer of his desk in 1968, beneath a stack of seed corn invoices, in a manila folder labeled in Albrecht's careful handwriting, "Land Transfer Original." She had almost thrown it away. She had assumed, looking at the date, that it was a copy of an old deed superseded by later transfers. Then at 4 a.m. on November 14th, 2022, while she was unable to sleep, she had opened the folder labeled Land Transfer Original and had read the document inside it more carefully. She had read it 3 times. Then she had called Roland. The deed that Verena Schoenfeld had found was a 5-page document. typed on a manual typewriter, dated August 7, 1968. It documented the transfer of the 320-acre Schoenfeld farm from Otto Schoenfeld to his son Albrecht for the consideration of $1 and the continuation of the family's stewardship of the land in accordance with the principles of community preservation set forth in the appended clause. The appended clause was on page 4. It was titled Family Preservation Reversion Clause. It read, in language that had been unusual even in 1968 and was, by 2022, almost archaic. The grantee, Albrecht Schoenfeld, and his heirs and assigns in perpetuity, shall hold this property under the following condition: that the property shall remain in the continuous ownership of the Schoenfeld family bloodline, and shall be actively farmed by a direct descendant of the original grantor Friedrich Schoenfeld, or the current grantor Otto Schoenfeld, for as long as such descendants survive and choose to maintain agricultural operation upon the land. In the event that any creditor, lien holder, mortgage company, or third party shall attempt to seize, foreclose upon, auction, or otherwise dispose of this property against the wishes of the family during a period in which the property is being actively farmed by a direct descendant, such attempt shall trigger an immediate reversion of full title to the original grantor's lineage. This clause is to be recorded as part of the chain of title, and shall bind all subsequent holders of any interest in property, including but not limited to any financial institution that accepts the property as collateral. Below the signatures were 3 witness signatures. 2 of them were neighbors, Mennonite farmers who had since died. The third was a notary public from Millersburg. Below the notary's signature was a small stamp from the Holmes County Recorder's Office, dated August 19, 1968, indicating that the deed had been formally recorded 12 days after its execution. The deed had been in the public record for 54 years. Nobody had read it. Heartland Federal Savings Bank, when it had originated the 2019 loan, had ordered a standard title search through a commercial title insurance company in Cleveland. The title search had identified the property's chain of ownership and had certified the title as clear, with no liens or encumbrances of record. The title insurance company had not flagged the Family Preservation Reversion Clause. They had not been trained to recognize such clauses. The clauses had become so rare by 2019 that they were no longer included in standard title examination protocols. Bertram Lindquist had not known about the clause when he had encouraged Matthias to take the loan. Matthias himself had not known about it. Albrecht Schoenfeld had told his son, on multiple occasions, that the farm was protected, but Matthias had taken this to mean spiritually protected, in the German-Mennonite tradition of viewing land as a divine trust. Otto Schoenfeld had inserted the clause at the time of the 1968 transfer because he had lived through the 1930s. He had watched the foreclosures of the Depression destroy 37 Mennonite farms in Holmes County. He had decided, when he transferred his farm to his son, that the same thing would never happen to his family. He had hired a lawyer in Millersburg, a German-Mennonite attorney named Wendell Geiger, and had asked him to draft a clause that would prevent the bank from ever taking the farm. Wendell Geiger had drafted the Family Preservation Reversion Clause. He had told Otto, this clause will protect your land for as long as it remains in your family's hands. The language is clear enough that no judge will refuse to honor it. Otto had paid him $42 for the work. The deed had been recorded. The clause had been preserved. Wendell Geiger died in 1981. Otto in 1989. Albrecht in 1991. Matthias had inherited the farm, but had not inherited the institutional memory of why his grandfather had gone to such trouble in 1968. He had not been told. The clause had simply waited. 54 years later, on the morning of November 18th, 2022, Judge Adelmar Reinhold of Holmes County Probate Court read the clause for the first time and understood within 4 minutes what he was looking at. When he banged his gavel and called for a 15-minute recess, he was giving the bank's attorney time to discover what her client had done. If you're hooked on this story, make sure to subscribe and turn on notifications so you never miss an upload. Your support means everything and helps me bring you more emotional stories like this one. Henrietta Calloway walked out of the courtroom and into the hallway. She took out her cell phone. She called the senior partner at her firm in Cleveland, a man named Dorrance Whitlock. The phone call lasted 9 minutes. She explained the situation. She read the relevant portions of the 1968 deed. She described the judge's reaction. She asked Dorrance what she should do. Dorrance was silent for a long time. Then he said, "Henrietta, the bank has a serious problem. The clause is enforceable. I have seen one of these before, a family preservation reversion clause from 1962 in Wayne County. The bank in that case lost. The court ruled that the clause attached to the property. The bank had to release the lien. What do I tell the judge? You concede. You concede before the judge has to issue a ruling. If you concede, the bank releases the lien voluntarily, and the public record shows that the bank acted in good faith. If the judge issues a ruling against you, we have a federal lending compliance problem. What about the loan? The loan still exists as a personal obligation against the state, but the collateral is gone. We're looking at a $450,000 write-off. That is preferable to a federal compliance investigation. How did this happen? It happened because the title insurance company missed a clause, which means the title insurance company is liable for the bank's losses. We will recover most of the loss from the insurer, but we will not recover property. The property is gone. It is going back to Mrs. Schoenfeld. Today. Concede. Apologize. Get out. Henrietta hung up the phone. She stood in the hallway for a long moment. Then she walked back into the courtroom. Verena Schoenfeld was still sitting at the defendant's table. Conrad Yutzi, the agricultural lawyer Roland had hired, had arrived during the recess. He was sitting beside Verena now, leather portfolio open on the table. Henrietta sat down at the bank's table. Judge Reinhold returned. The bailiff called the court back to order. Henrietta stood up. She said, "Your Honor, after consultation with our firm's senior partners, Heartland Federal Savings Bank wishes to formally withdraw its petition for foreclosure on the Schoenfeld property. The bank acknowledges a family preservation reversion clause documented in the 1968 deed, accepts that the clause attaches to the property and binds all subsequent encumbrances, and agrees to release its lien on the property effective immediately." Judge Reinhold looked at her. He said, "Counselor, will the bank pursue Mrs. Schoenfeld personally for any portion of the unpaid balance?" "No, Your Honor. Mrs. Schoenfeld was not a cosigner. She has no personal obligation." "Counselor, I want this on the record. I want the bank's commitment that no part of this debt will be pursued against Mrs. Schoenfeld personally. I want it on the record because if I find 6 months from now that your bank has assigned this debt to a collection agency and that agency is harassing this widow for repayment, I will be very interested in understanding why. Your Honor, the bank commits on the record that no portion of the outstanding loan balance will be pursued against Mrs. Schoenfeld personally, now or at any future time." Judge Reinhold nodded. He looked at Verena. He said, "Mrs. Schoenfeld, the court accepts the bank's withdrawal of its foreclosure petition. The 1968 deed is hereby entered into the permanent record of this court. The family preservation reversion clause is acknowledged as binding upon the property. The bank's lien is released. The property is yours, free and clear as of this moment." He paused. Then he said, "I want to add something on the record. In 14 years on this bench, I have presided over 473 foreclosure proceedings. This is the first time in my career that I have seen a foreclosure withdrawn at the moment of the hearing, because the borrower's family had thought to protect their land in 1968 and had documented the protection in a public record that the bank's title insurance company failed to discover. The Schoenfeld family's foresight in 1968 has saved this farm in 2022. I commend them for it." He banged the gavel. The courtroom emptied. Henrietta gathered her papers without looking at anyone. Conrad Yutzi stood up and shook Verena's hand. Roland Schoenfeld, who had been sitting in the back row in his veterinarian's work clothes because he'd come directly from a morning farm call, walked up to the front and embraced his mother. Verena did not say anything. She had not said a single word in court since she had stood up to enter the deed into the record. The deed had spoken for her. She held the manila folder in her left hand. She held her son's hand in her right. She walked out of the courthouse. It was 11:47 in the morning on November 18th, 2022. The hearing had begun at 10 o'clock. It had taken 1 hour and 47 minutes for Verena Schoenfeld to walk into a probate court as a widow facing the loss of her husband's farm and walkout as a widow whose farm could not be taken from her. Bertram Lindquist was not in the courtroom on November 18, 2022. He was in his office at the Heartland Federal Savings Branch in Worcester, where he had been the senior agricultural lender for 19 years. He learned the outcome of the hearing at 12:15 when Henrietta Calloway called him from her car in the courthouse parking lot. The phone call lasted 11 minutes. When Henrietta finished her summary, Bertram said, "Henrietta, I want to drive to Holmes County tomorrow. I want to apologize to Mrs. Schoenfeld in person. I want to do it on my own time, without the bank's authorization. Bertram, I am giving you advice as your colleague, not as counsel. Don't go. The bank will fire you. And whatever you say to her, no matter how well-intentioned, will be used against the bank in any future litigation. I don't think she's going to pursue litigation. You don't know that. I know her family. I've known the Schoenfelds for 19 years. They are not litigators. They are farmers. That is your professional judgment. It is not a basis for risking your job." Bertram said, "I am going to drive to Holmes County tomorrow. Thank you for the advice. I am taking the risk." He did not tell anyone at the bank. He left the office at 4:30 that afternoon, drove home, slept poorly, woke up at 5 in the morning on November 19th, and drove 93 miles south to the Schoenfeld farm. He arrived at 8:15. He parked in the gravel driveway. He sat in his car for several minutes before he got out. Verena Schoenfeld came out onto the front porch when she saw the car. She was holding a coffee mug. She was wearing a heavy wool sweater that had belonged to Matthias. She recognized Bertram immediately. She did not smile. She did not wave. She stood on the porch and waited for him to walk up. Bertram got out. He walked across the gravel driveway. He stopped at the bottom of the porch steps. He took off his hat, a habit from his German-Mennonite upbringing, which he had never quite shed. He said, "Mrs. Schoenfeld, I have come to apologize." She did not say anything. He said, "I encourage your husband to take the 2019 loan. I told him it was structured for an aging operator. I told him the bank would protect his family's equity. I was wrong about both of those things. If your father-in-law had not written the 1968 clause into the deed, the bank would have taken everything. I am the person who recommended that loan to your husband. I am responsible for the situation that brought you into court yesterday. I have come here to tell you that I am sorry." Verena looked at him. She had thought, for many weeks, about what she would say to Bertram Lindquist if she ever saw him again. She had rehearsed angry words. She had rehearsed cold dismissal. She had rehearsed silence. What she said, in the moment, was something she had not rehearsed. She said, "Bertram, sit down. I will pour you a cup of coffee." She did not say it warmly. She did not say it forgivingly. She said it the way a German-Mennonite woman of her generation said anything to a man who had come to her porch in the proper way, with his hat in his hand, asking nothing for himself. She said it because hospitality, in the Mennonite tradition she had been raised in, was not a reward for good behavior. It was an obligation. She poured Bertram a cup of coffee. She sat across from him on the porch. They drank in silence for several minutes. Then Verena said, "Bertram, the deed is 54 years old. My father-in-law put it there in 1968 because he had watched what the banks did in the 1930s. He never told my husband what the deed said. My husband did not know. I did not know. I found it 4 days before the hearing. If I had not found it, your bank would have taken this farm." "I know. And you would have allowed it." "Yes, I would have allowed it. That is what my job has been for 19 years. And now," Bertram set his coffee cup down. He said, "Mrs. Schoenfeld, I am 58. I am going to retire next year. After yesterday, I do not believe I can do this work for 2 more years. I am going to leave the bank." Verena nodded slowly. She said, "Bertram, would you like to come to dinner on Sunday? Roland and his wife will be here. My daughters are coming. You are welcome at our table." Bertram looked at her. He said, "Mrs. Schoenfeld, after what I almost did to your family, would you invite me to dinner?" "Bertram, you did almost nothing for my family. You did exactly what your job required you to do. The man who put the protection in place was my husband's grandfather. You are not the bank. You are a man my husband trusted, who came to my porch with his hat in his hand. You are welcome at our table on Sunday." Bertram did not know what to say. He said, "Thank you. I will come." He came to dinner on Sunday, November 22nd, 2022. He sat at the table with Verena, with Roland's wife Melisande, with both Schoenfeld daughters, and with the grandchildren. He drove home in the dark. He went into his office on Monday morning and submitted his resignation effective December 31st, 2022. He did not return to commercial banking. The Schoenfeld farm did not return to immediate normalcy after November 18th, 2022. The dairy operation continued. The corn went into the bins. The mortgage was released. The probate process continued for another 14 months. Verena did not run the farm alone. She hired her son Roland's college friend, a farmer in his early 40s named Dwayne Hostler, to manage the day-to-day operations on a profit-sharing basis. Dwayne moved into the small tenant house in February of 2023. The dairy operation continued under Dwayne's management. The corn yield stabilized. The grain bins reached capacity for the first time in 3 years. Verena focused on the things she had always focused on: the garden, the household accounts, the German language Bible study she hosted at her kitchen table on Wednesday evenings, the grandchildren who came to visit on Sundays. She also did one thing she had never done before. In February of 2023, she drove to the offices of Conrad Yutzy in Worcester. She brought the 1968 deed with her. She asked Conrad to draft new documents, a similar reversion clause written into a new deed structure that would re-record the family preservation protection for the next generation. Conrad worked on the documents for 3 weeks. He delivered them in March of 2023. The new deeds preserved the 1968 clause. They extended its protection forward. They ensured that no future bank, no future loan, no future financial circumstance could ever take the Schoenfeld farm out of family hands as long as one direct descendant was actively farming the land. Verena signed the deeds. She filed them with the Holmes County Recorder's Office. She paid the recording fees, which came to $32. She put them in the same desk drawer where Albrecht had kept the 1968 original. She did not tell her children what she had done. She had decided, based on what had happened to her own family, that the protection should remain quiet, should remain available without being explained, should wait the way the 1968 clause had waited until it was needed. The 1968 deed itself was donated by Verena to the Holmes County Historical Society in the summer of 2024, after the probate had been finalized. The deed is now displayed in a glass case alongside 3 other family preservation reversion clauses that Conrad Yutzy was able to identify in his subsequent research, all dated between 1957 and 1971. Conrad Yutzy began, in late 2023, a quiet practice of his own. He began offering, to any agricultural client who came to him with property and family ownership, the option of including a modern version of the Family Preservation Reversion Clause in their deeds. The clause has been included in 23 deeds in Holmes, Wayne, and Tuscarawas counties between November of 2023 and the present. Conrad does not charge extra for clause. The Heartland Federal Savings Bank survived the loss on the Schoenfeld loan. The bank recovered most of the $450,000 write-off through litigation against a title insurance company. The bank also revised its title examination protocols to include a specific search for family preservation reversion clauses. Bertram Lindquist did not return to banking. He bought a small 15-acre property outside Worcester in March of 2023 and began raising sheep. He visits the Schoenfeld farm 3 or 4 times a year. He brings flowers for Verena in the spring. He sits at her table on Christmas Eve. He has told 3 different friends over the years since November 2022, the same sentence about Verena Schoenfeld. He has said, "That woman should have hated me. She had every right. Instead, she invited me to dinner." The wooden desk that Albrecht Schoenfeld had used for 43 years, and that his father Otto had used for 36 years before him, still sits in the small office at the back of the Schoenfeld farmhouse. It is made of oak hand-built by Otto's brother Reinhardt in 1934. It has 6 drawers. The bottom drawer on the right side is the deepest. That is a drawer where the 1968 deed was found. That is a drawer where Verena Schoenfeld now keeps the 2023 deeds. The drawer is unlocked. It has never been locked. The protection in the drawer is not protected by lock. It is protected by tradition, by the slow, quiet, multi-generational tradition of German-Mennonite farmers who file important documents in the bottom drawer of the family desk and trust that the next person who needs them will know where to look. Verena's eldest daughter, Annalise, came to visit in the summer of 2024. She was 41 years old. She lived in Columbus. While she was visiting, Verena took her into the office. She showed her the desk. She showed her the bottom drawer. She did not open it. She did not show her daughter what was inside. She said, "Annalise, if anything ever happens to me, if you and your sister and Roland are ever uncertain about what to do with the farm, if a bank ever comes for it, you look in this drawer. There are documents here that will help you. I am not going to tell you what they say. Your great-grandfather did not tell my husband what was in his drawer in 1968. I am not going to tell you what is in mine." Annalise looked at her mother for a long moment. She said, "Mother, why won't you tell us what's in it?" Verena thought about it. Then she said, "Annalise, some things are better when they are found, not when they are explained. Your great-grandfather understood this. I understand it now. When the time comes, if the time comes, you will find what you need, and it will mean more to you because you found it yourself." Annalise nodded slowly. She did not press further. She remembered the desk. She remembered the drawer. She remembered the office. That was what her mother had asked of her. That was enough. Verena Schoenfeld is still alive. She is 66 years old as of this telling. She lives on the farm. She tends the garden. She hosts the Wednesday Bible study. She watches her grandchildren on Sunday afternoons. She visits Bertram Lindquist's sheep operation twice a year. The 1968 deed is in the Historical Society's glass case. The 2023 deeds are in her bottom desk drawer. The farm is in her family's hands. The protection is in place. Some inheritances are loud. The Schoenfeld inheritance has been quiet. Some of the most powerful protections that ever existed in American agriculture are not in laws, are not in regulations, are not in modern banking compliance frameworks. They are in the bottom drawers of old wooden desks in farmhouse offices in counties most Americans have never heard of, written by men who lived through foreclosures of the 1930s and decided that what had happened to their neighbors would not happen to their families. Otto Schoenfeld decided this in 1968. His granddaughter-in-law preserved the decision in 2023. The drawer is still unlocked. The deed is still inside. The farm is still in family hands. That is the whole story. A widow found a deed in a desk drawer 4 days before a court hearing. She did not know what she was looking at. A judge read the document for 4 minutes and called a recess. A widow walked out of a courtroom with her husband's farm intact. A banker drove 93 miles the next morning to apologize. A widow invited him to Sunday dinner. That is not, in conventional sense, how foreclosures end, but it is how this one ended. It ended because Otto Schoenfeld, in 1968, sat in a Mennonite attorney's office in Millersburg and paid $42 for a clause that no banker in 2022 had been trained to recognize. $42. 54 years of protection. One farm saved. The slowest, quietest, most patient form of love that a man could ever leave for the great-grandchildren he would never meet. Otto Schoenfeld did not need to meet them. He had only needed to imagine them. That had been enough. Thank you so much for watching until the end. If you loved this story, check out the other videos on your screen now. I think you'll really enjoy them. And don't forget to subscribe if you haven't already. See you in the next story.